Hi everyone, I'm immigration attorney Zeitoun-Sedki, and our topic today is on the K-1 fiancé visa. So you are engaged and you are wondering how you should bring your fiancé to the United States. There are many different ways on how we can approach this, so that's why it's important that if you have a unique situation that you would like to discuss with my office, just give me a call. We'll set up a consultation so we can understand all the details about your case and I can advise you on your personal case. But today we are going to be talking about just the general requirements for bringing your fiancé to the United States and how you should begin the process so that they can successfully come here. So let's begin. You have now got formally engaged with your fiancé and you are looking to bring them to the United States. Now, if they are overseas, then you will be going through something called a consular process in order for your fiancé to secure the visa at the U.S. Embassy in their country. But the process will actually begin in the United States. So if you are a U.S. citizen and you are required to be a U.S. citizen in order to bring your fiancé to the United States, you will start the process here through the United States Citizenship and Immigration Services, or USCIS. The form will actually be filed here in the United States and it will go through a process until the application actually reaches the U.S. Embassy in your fiancé's home country. You will go through something called the National Visa Center, which is an agency, part of immigration, that is responsible for the visa application that actually gets filed for the visa to be issued to your fiancé. So one of the main requirements to bringing your fiancé to the United States is that there is a requirement that you would have had to met them in person within 2 years of filing the petition. So that means that you and your fiancé would have had to have met either in the fiancé's home country, or perhaps the fiancé has visited the United States in the last 2 years and you have physically met. Now, I have gotten many cases that have come to my office where this hasn't happened yet because perhaps you have met online through an online dating site, so the physical meet has not happened. Now, this could actually be very problematic when it comes time for approval of that petition. So again, very important that you talk to your lawyer about this before filing the petition in order to avoid a denial of that petition. So that's one of the main requirements. Now, if you have met the actual meeting requirement, you do need to show the immigration that you have every intention to marry this individual. So in preparing the actual petition, there are some documents that need to be filed showing that there is a plan or there is an intention for the two of you to actually get married once your fiancé actually comes to the United States. There are a list of documents and different examples on how you can actually show that, but we can talk about that at a later time. Today, we're going to talk about how do you get that petition approved and how does it get to the U.S. Embassy so your fiancé can secure the visa and come to the United States. Now, once the petition is approved and the fiancé is scheduled for an interview, it's also very important to have your fiancé prepared to address certain questions that the consular officer is going to ask. For instance, they might ask when they are planning to get married, or where do they plan to live once the marriage actually takes place. Which brings me to my next point. As a requirement for the K-1 visa, the couple needs to get married within 90 days of entry to the United States. So it's very important that once your fiancé secures the visa in their passport and has plans to come to the United States, that you as a couple have plans on getting married within that 90-day window after he or she enters the United States. This should be planned ahead of time because oftentimes in my office, I do see that people come into the United States, but they have not planned well ahead of time to meet that 90-day deadline. Now, once the marriage has already been, it's a legal marriage and it's already been recorded, then that is what your lawyer will need in order for your fiancé to apply for adjustment of status, or in other words, under immigration, it's considered a green card. So in order for he or she to apply for a green card, you have had to have gotten married within that 90 days. There are many situations when the couple does have problems and the relationship does not result in a marriage. Now, this could be a very problematic situation for the person coming on the K-1 visa. So if you do have an issue where a marriage has not occurred, and you are here in the United States on a K-1, it is very important that you consult with an immigration attorney to know what your options are, because this could be considered a violation and you will be required to return back to your native country. Remember, if you have a unique situation, you're going to want to contact my office, and someone from my friendly staff will contact you back and set up a consultation with me personally so we can discuss all the details of your case. You can call or you can email my office at any time. Thank you for watching. I hope you found this video to be informative. Remember to subscribe to the channel, and I will see you next time.